What should I expect in my jury trial in Tennessee? Hi, I'm John Griffith. I'm a personal injury trial lawyer practicing law in Tennessee. There are many steps that need to take place in order to be prepared, fully prepared for a jury trial. Number one, voir dire, also known as jury selection. This is one of the most important phases of trial in which your lawyer must introduce you and some of the basic premises of your case and share them with prospective members of the jury. This is the only chance for your lawyer and the other lawyer to find out the preconceived notions, prejudices, biases that some jurors may have. At the close of voir dire, each attorney representing each different party gets a certain set of challenges to strike a juror from being in the ultimate jury pool. Why is that? Sometimes you may just have a bad feeling against a certain type of juror, or you may receive some answers in your voir dire that indicate that they might not be fair to your side. The purpose of voir dire is selecting a jury that's going to be as fair to both sides as possible. The second phase of trial is opening statement. This is the part of the trial where both sides get to tell their side of the story about the facts of the case as they anticipate they're going to be presented during the course of trial. You are not permitted to argue during opening statement. You only get to tell your story. You do get to set forth what the witnesses are expected to say based on prior deposition testimony and prior factual documents that have been submitted to the court. The third phase is the plaintiff's proof. The plaintiff must prove that the defendant or defendants were negligent and that negligence was the cause of your injury. So what's included in the plaintiff's proof? It could be experts on the negligence of the defendant, experts in medical care to prove your harms and losses, your injuries, your permanent injury, your proof of things you may not be able to do in the future, proof of permanent surgeries or future medical care that you're going to need because of this incident. Also during your proof, many times the plaintiff themselves will testify, as well as any supporting witnesses, family members, friends, co-workers that can tell the jury the difference between that person before this incident occurred that changed their life versus after this incident. The next step is the defense proof. The defense will do everything they can to fight the plaintiff on their theories of negligence and also on the area of harms and losses actually caused to the plaintiff. The last phase of the trial, as far as the jury is involved, is closing arguments, a time for both sides to argue their case based on the facts that were presented to the jury. At the end of the closing arguments, the jury will be instructed on the law that the judge will charge them, and they are to follow that law when they go back and begin their deliberations. Tennessee juries require a unanimous jury to render a verdict. The results of the deliberation are put down on the verdict form. This verdict form is later handed to the judge and read to the parties after the jury is called back into the courtroom. The verdict is read, and the jury is usually then dismissed and allowed to leave and thanked for their service. A jury's verdict is given heavy weight by Tennessee courts when they have reached their conclusions of law and fact. So why is a jury's job so important? It's important because many times the standard of care for the local laws in your community are going to be set forth by what the jury concludes in its verdict. If a jury finds that it's improper and negligent for a company to put gas tanks in the rear of a car where it's more likely to explode, they're going to reflect that in their verdicts. Companies, especially insurance companies, listen to these verdicts. They're reported and they're extremely important. Conversely, if a jury doesn't find something important in their community and thinks it's okay to have gas tanks in the backs of the cars that could explode, then companies will continue to do those type of activities that are cheaper that they can get away with. So if you're being asked to be on a jury, know that you are setting the standard of care for your community anytime you sit on that jury panel. If you have questions about your case, call me. I'm here to help. I can be reached at 615-807-7900 or email me at john@griffithinjurylaw.com.